Welcome everyone to our session on GDPR Article 12, Transparency and Communication. This is a foundational article within the General Data Protection Regulation, designed to empower individuals and ensure absolute clarity in how their personal data is handled by organizations. Article 12 isn't about what information you provide, it's about how you provide it. Whether you're sending a privacy notice or responding to a subject access request, Article 12 sets the ground rules for clear and accessible communication. Now, let's dive into the how of this communication. Article 12 lays out crucial principles to guide organizations. First, information must be concise, get straight to the point, no unnecessary jargon or legalese. Second, it must be transparent. This means being open and honest about all data processing practices. Third, intelligible, meaning easy to understand even for those without a legal background. And fourth, easily accessible, so individuals can find and read privacy policies or relevant information without a scavenger hunt. This includes prominent links on websites, for example. A critical point here is that for information addressed specifically to a child, the language must be particularly clear and plain, reflecting their comprehension level. When it comes to the methods of communication, organizations have flexibility. Information can be provided in writing, such as through a comprehensive privacy policy on your website. It can also be delivered by electronic means, like an email notification or a website pop-up. And, if the data subject specifically requests it, and their identity can be proven, information can even be provided orally. Now, a very important aspect is the cost. All information and communication provided under Article 12, and any actions taken regarding data subject rights, must be free of charge. There is a narrow exception. A reasonable fee may be charged only for requests that are manifestly unfounded, excessive, or repetitive, or if the data subject requests extra copies of information already provided. Timeliness is paramount when responding to data subject requests, whether it's for access, rectification, or erasure of data. The default timeline is that organizations must respond without undue delay and in any event within 1 month of receiving the request. However, the GDPR acknowledges that some requests are more complex. This period can be extended by 2 further months if necessary, especially when dealing with highly complex requests or a large number of requests from an individual. It's crucial to remember that if you do extend the period, you must inform the data subject of this extension and provide the reasons for the delay within initial 1-month timeframe. Refusal to act on requests. While organizations are generally expected to act on data subject requests, there are specific conditions under which a request might be refused. If an organization decides not to act on a data subject's request, it has a clear obligation to inform the data subject of this decision without undue delay and at the latest within 1 month of receiving the request. This refusal communication must be comprehensive. It needs to include the specific reasons for not taking action, information on the data subject's right to lodge a complaint with a supervisory authority, and details on how they can seek a judicial remedy if they disagree with the refusal. To summarize, here are the key takeaways for organizations striving for Article 12 compliance. First, prioritize clarity in all your privacy-related communications, make them genuinely easy for anyone to understand. Second, be responsive, act promptly and within the specified timelines for data subject requests. Third, document everything, maintain thorough records of all communications and actions taken regarding these rights. And finally, train your staff, ensure all employees who might interact with personal data or data subject requests fully understand their obligations under GDPR Article 12. These steps are vital for building trust and maintaining compliance. That concludes our overview of GDPR Article 12. Now, I'd like to open the floor for your questions and discussion. Let's talk about how your organization currently ensures compliance with Article 12, or any challenges you might be facing. What are your thoughts? In the next video, we'll explore Articles 13 and 14, the exact info you must give when collecting data from users. So if you want to know what your privacy notice must include, don't miss it. Like this video, subscribe to @SIP GDPR Guide, and comment your doubts below. See you next time.